All right, it's live streaming. I'm gonna record as a backup, so you're good.
Okay, so, good evening, everyone. Christine, thank you so much for being here this evening. We have a guest, the Deputy Director, Counsel Christine O'Neill. She's from the New York State Committee on Open Government. I wanted to make sure that we had this today so that we could start out our program year well informed on how to operate open meetings. And I wanted to, the ability to ask for anyone in the community or here to ask any questions that you have about open meetings law or, having an open meeting or any questions about handling the public. So I want to quickly get started because Christine has a hard stop. And so I'm going to put this over to Christine to do her presentation. Christine, are you ready?
Hi, it's Kristen, but how are you? Thank you.
Oh, sorry, Kristen. Sorry. Apologize.
So what I need is someone to give me presenter rights. Because I'm not able to share my PowerPoint right now.
Jeremy, are you there?
Maybe I am, because before I was getting a message saying I wasn't allowed to. Are you able to see my PowerPoint?
Yes, I am.
Okay, awesome. Great. Okay. Then no worries, we're all set.
Okay, wonderful. Thank you.
Sure. So my name's Kristen O'Neill. I am the Deputy Director and Counsel for the New York State Committee on Open Government. We are a government agency that's housed within the Department of State, the New York State Department of State. And our role is to provide advice and guidance, legal opinions regarding the Freedom of Information Law and the Open Meetings Law. So tonight we're going to focus on the Open Meetings Law. And actually, I think I just pulled up the wrong PowerPoint. I apologize, but let's see, hold on just a second. You know what? It's all right. Even if I modified one of these just because I wanted to include some specific information about, nope, this is all good. We're all good. Sorry, I apologize. Anyway, I was worried that I had opened up the wrong PowerPoint, but I didn't.
Okay.
So tonight we're going to be focusing on the open meetings law. Up on the screen right now is my contact information and the contact information for the office generally, because we're a tiny office. We're a staff of 5 individuals. We have 4 attorneys. Excuse me, we have a staff of 6 now because we were able to just hire an administrative analyst who's going to sort of help us do some work with our older documents and hopefully organize the information that we do have in a way that's more useful to the public. We have 50 years worth of advisory opinions and guidance. We have quite a bit of information posted on our website, but our goal is to make it more accessible and cleaner and up to date, and make sure that any information that we do have on our website isn't outdated due to subsequent amendments to the statute or judicial precedent, things of that nature. So we were very lucky we were able to hire someone just to focus on that project. So we have 4 attorneys, the administrative analyst, and our secretary. So that is our entire office. If you ever have questions about either FOIL or the open meetings law, you're always welcome to contact me. I don't mind you contacting me directly, but sometimes the easiest thing to do is either just call our office at the phone number that you see there, or email that email address, that coog@dos.ny.gov. That way, the attorney that is first able to get back to you will do so. For example, I'm going to be gone all day doing training in Saratoga and will probably not see emails most of the day. So sometimes it's best to use those generic contacts and you get an answer more quickly. Up on the screen, you see what our website looks like. Usually there's some sort of headline up there. For the past week or so, past couple days, we've had some new information that we want to make available about amendments to the Freedom of Information Law. There was an amendment to FOIL relating to a notification requirement. So if a Freedom of Information Law request is made for a disciplinary record of a public employee, the law now contains a requirement that every agency establish a policy for notifying that public employee that records about them have been disclosed. So we have a headline up on our website with information about that amendment. And we've just had a couple of other issues come up recently that we've wanted to address. So usually we put all that front and center right up on our website. So it's a good place to check in every once in a while. On that website, we have copies of both the Freedom of Information Law and the Open Meetings Law. We keep it up to date. We have advisory opinions that are indexed alphabetically by key phrase, but are also searchable by key phrase. So if you're looking for advisory opinions about executive session, for example, you can scroll down to that alphabetical category, or you can search a term. As we go through tonight, I'm going to stop periodically and see if people have questions about things. That way, if you have something and you want to ask it while it's still fresh in your mind, you can. But also, if you would prefer, if you just want to type your question in the chat box and I'll answer it at the end. Because I'm working from one screen, it's hard for me to see the chats as they come in without disrupting the flow of the presentation. But I will pause periodically for verbal questions. The Open Meetings Law is codified in Public Officers Law, Article 7. It was enacted in 1976. And the point of the Open Meetings Law is that public business must be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. All citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So it's not just about the right of the citizens to be present when the votes occur. It's also about the right to sort of see how the sausage is being made. They have the right to listen in on the deliberations of the members of the public body as they discuss the policies that they want to make and who thinks what about what. And they should have the right to see if one of your members isn't comfortable with something and wants to ask questions. That should all be occurring out in the public and as part of the deliberative process. The Open Meetings Law governs meetings of public bodies. So what's a public body? To some extent, there's certain things that everyone understands are public bodies. It's fairly straightforward. But others, it's a little bit more of a question mark. The Open Meetings Law defines a public body as any entity for which a quorum is required in order to conduct public business. It has to consist of 2 or more members performing a governmental function for the state, or for an agency or department, or a public corporation as defined in the general construction law. For example, cities, New York City or Albany or Rochester, Buffalo, or towns and villages, even school districts are public corporations as defined in General 66 of the general construction law. Public bodies, the definition also includes any committee or subcommittee or other similar body consisting of members of such public body. So, for example, community boards are public bodies, and any committee or subcommittee that is made up entirely or primarily of members of the community board are also public bodies. So anytime you have a committee meeting, that committee meeting must also be held in compliance with the Open Meetings Law. The definition also includes any entity created or appointed to perform a necessary function in the decision-making process for which a quorum is required in order to conduct public business and which consists of 2 or more members. That's probably where community boards are going to come in. They're going to fit into that part of the definition. The law also states that a necessary function in the decision-making process shall not include the provision of recommendations or guidance which is purely advisory and does not require further action by the state or agency or department thereof or public corporation. So, for example, if I don't know if this happens within community boards, perhaps it does, but I'll use maybe my own experience is a little easier for me to explain. I live in the city of Albany. If the Albany City Council decides that it wants to create a citizens advisory committee relating to parks and recreation in the city of Albany, and the people who serve on that advisory committee are residents of the city, business owners of the city, maybe students in the local school districts, Maybe you have 1 or 2 liaisons from the city council, but primarily this advisory committee is made up of people who don't serve on the city council or any of the other public bodies established within the city. So in those types of advisory bodies, they generally are not going to be considered public bodies that are subject to the open meetings law, because they're just coming up with advice and recommendations. They're sharing that information with the city council with, hope and a prayer that the city council is going to adopt some of their recommendations. Quorum. Whenever 3 or more public officers are given any public power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number of those individuals gathered together in the presence of each other or through the use of video conferencing shall constitute a quorum. Not less than that quorum can perform and exercise the power, authority, or duty delegated to that group of individuals. So for the purposes of this provision in general, this is a definition of quorum that comes from New York State general construction law. And the definition in that statute says, for the purpose of this provision, the words whole number shall be construed to mean the total number of the body that the body would have if there were no vacancies and none of the persons or officers were disqualified from acting. In general, for most public bodies, in order for that entity to have a meeting, you have to have a quorum present, which is true for community boards as well, but you also need to have any action item that needs to get passed has to have the approval of the majority of the total membership. So here's where a little pink glitch comes in terms of community boards. Perhaps a year or 2 ago, I can't remember how far back it was, somebody reached out to me with a question, and actually I have to take full responsibility. My initial answer was incorrect because I was not aware of provision of the New York City Charter. New York City Charter is not in any way my expertise. I did not know this provision existed. I gave general guidance about what the definition of quorum is based on my knowledge of general construction law. Then somebody else from one of the other community boards, and maybe it's somebody who's on this presentation today, I honestly can't recall, brought to my attention this provision of New York City Charter, section 2801 sub B, which states that whenever any act is authorized to be done or any determination or decision made by any community board, the act, determination, or decision of the majority of the members present entitled to vote during the presence of a quorum shall be held to be the act, determination, or decision of such board. So what does that mean? It's a lot of language there. First, you do have to get a quorum to show up at the meeting. But second, in order for a motion to pass or resolution to pass, you only need the majority of those board members that show up to the meeting to vote in favor. So that's something that's very specific and different about community boards. And here's just a little bit of analysis. I'm not going to go over it, but if you all want to read a copy of that opinion, if you haven't seen it, I'm happy to send it out after the presentation. It is Open Meetings Law Advisory Opinion number 5664, where I specifically go into the reasons why community boards are allowed to have a different rule than what other public bodies are required to comply with. Before I move on, does anyone have any questions at this point? Okay.
Yeah, we have a question.
Good question, Kristen. How are you? Richard Axel here from the committee. So for community board quorum, is it possible to have quorum online, 3 or more members, or is that only officials, public officials?
I don't understand that question.
So no, so
give me a
we've been
number for your
advised now.
community board.
Excuse me?
How many people are appointed to your community board?
About 50.
50, let's say 50.
Okay. So in order to have a meeting, you have to have a minimum of 26 people show up to the meeting in order to pass any motion, or you actually have to have a quorum present in the room.
So that's my question, is the in-person part.
All right, we're going to go into that in a lot more detail,
Okay,
the
so go
rules
ahead.
relating to video conferencing.
So then I'll hold my
Then-
question.
Kristen,
Okay, yeah,
can you hear me?
I can.
Hi, this is Cynthia Rodriguez. And one of the, just to clarify, the community boards are allowed up to 50 people. It doesn't necessarily mean that the community board has 50 people. Right now, our board has 42 appointed members. So I guess part of the question is, in terms of this quorum requirement, the number that we should be guided by, is it the 50 that can potentially be appointed, or is it the 42 that currently are appointed members?
It's generally the number if you had no vacancies. So right now you have 8 vacancies, it sounds like. You could appoint up to 50, but you just haven't been able to fill those spots. So the number that you would be working with is 50.
Thank you.
Mm-hmm. Has your community board adopted an extraordinary circumstances video conferencing resolution authorizing the use of video conferencing under extraordinary circumstances?
I don't think it's codified in our bylaws because we just defer to the open meetings law.
Okay, the open
But
meetings law requires, if you want to use the video conferencing provision, that you had to pass a resolution.
yeah, we did that and it's on our website. I can send you the link if you want.
Awesome. Nope, no, I don't need to see it. I was just asking for purposes of to see whether this was a useful conversation or not. I want to see, what you guys actually do. So in the spring of 2022, Governor Hochul signed Chapter 56 of the laws of 2022. And this was even before some of the temporary legislation that had been in place during the COVID health emergency. There was still some temporary legislation in place that allowed for fully remote meetings due to the COVID state of emergency. But so in April of 2022, the open meetings law was amended to include an expansion of the use of video conferencing by public bodies to conduct their meetings. But this expansion was limited to allow members of the public body to attend from a private location, a place that's not open to the public, their homes, their offices, maybe it's out of state. But they're only permitted to do this under the term is extraordinary circumstances. In order to do this, the public bodies were required to pass a resolution, which it sounds like you did, authorizing the use of this extended use of video conferencing. This new added provision doesn't change what you were allowed to do pre-COVID. If, for example, we at the Committee on Open Government used video conferencing even before the start of the pandemic, it's just that our use of video conferencing was that we would have a location in Buffalo, one in Albany, and one in New York City at Department of State offices. Our meeting notice would go out stating that our members would be attending from one of those 3 locations and that the public was invited to attend from one of those 3 locations. Then we would connect all 3 of those locations through the use of video conferencing. So that's been permitted for many, many years. I want to say it's been permitted for like 20 years now. And that existed pre-pandemic, and it continues to exist, where you have members attending from public open locations, and those locations are connected through the use of video conferencing. This new amendment is for when somebody cannot attend from a public location, where they want to be able to attend from a private location. So there's those two ways of using video conferencing. One is where you're connecting multiple physical locations that are open to in-person public attendance. And the second is where you allow your member to participate from a private location through video conferencing, but only under extraordinary circumstances. The Open Meetings Law defines extraordinary circumstances to include disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at the meeting. So here, I'm going to go back to quorum for a minute because there's a little unusual aspect with quorums. In general, members who are participating from a physical location that has been properly noticed and is open to in-person public attendance, so the actual physical meeting site where most of your members are attending from, all of those people that show up to that open meeting site count towards a quorum. And they can, of course, fully participate and vote in the meeting. Members who are video conferencing from a remote location that is not open to in-person public attendance do not count towards a quorum most of the time, unless they meet a particular disability criteria. That disability criteria is when a member is participating from a remote location due to the extraordinary circumstance of being disabled, and that disability prevents them from attending in person. So the law was amended in 2022 originally that says no one that attends remotely counts towards a quorum. And then it was amended again in 2023 to say, if you have a disability and that disability prevents you from attending in person, then you count towards a quorum. But if you're attending via video conferencing due to illness or caregiving responsibility, you do not count towards a quorum. But once you get that quorum, once you have a quorum in an open physical location, those individuals that were permitted to attend via video conferencing can fully participate and vote. All right, I'm going to stop there because even though it's only a couple of slides, it's a lot of information. See if people have questions about that aspect.
Kristen,
Mm-hmm.
your slideshow is not moving. It's
All right, what slide are you on?
I only see the first slide.
All right, I'm
I
going to
don't
close
know.
it and try. I'm going to
There you
try.
go.
Yeah.
Good now.
Now we got it.
Are you guys seeing it in that weird format?
Yeah.
I'm just going to try to reopen and see what happens. I don't want you to, if you're having a problem. Did it move forward this time?
No.
Oh, I'm sorry. All
That's
right.
okay.
All right, I'm just gonna, I guess I'll just use that other format. It doesn't look as nice, but at least you can see it.
Yeah.
That's fine.
And I will send you guys, I'll send you these slides as soon as we're done, and you can distribute as you see fit to anyone who would like them.
Awesome.
Yep.
Thank you.
No
Hi,
problem.
Kristen.
Sorry about that.
This is Cynthia again. Can you still hear me? Sorry,
I
I'm
can.
driving.
Oh, it's okay. Go ahead.
Okay, so in terms of disability, what kind of proof or documentation, if any, would be required to be able to use disability as an exemption or whatever to count towards the quorum?
The only thing I'll say is that they specify that it's disability as defined in section 292 of New York State Executive Law. But what you as a public body individually are going to require in order to take advantage of that provision, that's up to you. Personally, I don't know what I want to get into a fuss with people about.
Right.
If so, right? Yeah. If someone
Yeah,
tells
no,
me that, I'm
absolutely.
not going to argue with them, but that's just my personal.
Can you kindly put that in the chat, the reference you just mentioned? Thank you so much.
Sure. Hold on just a second so I don't forget. There, chat.
Because I have a question, Kristen.
Yep.
So,
Go ahead.
I work in healthcare, so I have an issue if the person needs to show proof, right? Because if they have a medical condition that they don't want people to know, or, how do you handle those situations?
Which is sort of the reason why I said I would be hesitant to honestly even require proof. What I would do, consult with what if you have resources, like for example with the city human resource administration that can provide you some type of guidance in that area. It's probably best coming from them rather than me, because I am not a disabilities lawyer. I am not someone, my area of specialty is open government, and I don't want to provide you with incorrect guidance. I just would say that personally, if someone came to me and said, I have a disability that prevents me from attending in person, I would be like, okay, you're in. I wouldn't quite, I wouldn't be inclined to get into a discussion or requiring them proof, but that is just entirely me. That's not me as a lawyer. That's just me as I don't want to get into that discussion or argument with somebody about whether they meet a particular criteria or not.
Thank you.
Sure. Yeah, I understand where you're coming from. Does anyone else have any questions about video conferencing? Okay, move on. Notice of all meetings of a public body must include the date, time, and location, and if appropriate, instructions for virtual attendance. So for example, if you are offering a WebEx or Zoom or whatever the case may be, you want to make sure your meeting notice includes a link or instructions for how to log on to that virtual meeting. The meeting notice must be given prior to every meeting. Although when I say that, it also could be that if you have a schedule of meetings that you establish at the beginning of your business year or calendar year, and you stick to that schedule, it's fine to just put the notice out once at the beginning of the year. Maybe it's posted to your website at the beginning of the year. It's sent to the media once at the beginning of the year, and it's posted in a designated physical location once at the beginning of the year. That's fine. The only time you're going to need to make, that's maybe a subsequent notice is when, if there are changes, there's changes to the date, time, or location for a meeting, or if you need to add a meeting that wasn't on your original schedule, then you're going to want to put out notice within the timeframes that I'm going to discuss in a moment. Again, remember, it has to be prior to every meeting, must be given to the media. Does not mean you need to purchase a legal notice. It just means the media must be put on notice, must be placed in a designated physical location, which quite honestly is a holdover from the fact that this law was passed in 1976, because I'm not sure how often people are going to designated physical locations to find out when a meeting is. Probably more likely maybe in a small town up near the Canadian border than in New York City, but you never know. And if you have a website, if you have an active website, it has to be posted on your website. Oh, forgot I'm not in a different kind of presentation. That for timing, it has to be at least 72 hours prior to any meeting that was scheduled at least 1 week in advance. If you're scheduling a meeting less than a week in advance, you have to give notice to the extent practicable at a reasonable time prior to the meeting. The open meetings law itself is silent as to when you're allowed to have those meetings on short notice, but it went to the courts. And years ago, the courts weighed in and said that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. So if no harm would be caused by waiting until your next regularly scheduled meeting, that's what should be done. But there are circumstances where governing bodies, public bodies, need to make a decision quickly, and something of an emergent nature, I'm going to say, has come up, and that decision needs to be made quickly, and you might need to have a meeting on short notice. Again, I'll note that if extraordinary circumstances video conferencing is used, the notice has to inform the public of that and give instructions for how they can view or participate in the meeting. Records scheduled to be discussed. In the fall of 2021, Governor Hochul signed Chapter 41 of the Laws of 21, amended Section 103E of the Open Meetings Law to require that records to be discussed at an open meeting must be made available to the extent practicable upon request and posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. So this wasn't a brand new obligation. The obligation to make records available to the public upon request used to be prior to or at the meeting, and you had to post the records on your website prior to the meeting. And that had been in effect since February of 2012. So it had been around for almost 10 years by the time this amendment came around. This law, this amendment from the fall of 21, simply placed a 24-hour minimum time frame for making those records available. So what kind of records are we talking about? Any proposed resolutions, laws, rules, regulations, policies, or any amendments to any of those items need to be made available at least 24 hours prior. Any records or portions of records that would be available under the Freedom of Information Law that are scheduled to be discussed during the open meeting. Those are also records that need to be made available at least 24 hours prior to the meeting. The law states that the agency may, but is not required to spend additional money to implement this section, and it does not apply to records discussed in executive session. So if for some reason you're discussing something that is an appropriate topic for executive session, the records associated with that conversation do not need to be made available 24 hours prior to the meeting. Minutes of any meeting must include, it's fairly bare boned, has to include a record or summary of all motions, proposals, resolutions, or any matter formally voted upon and the votes thereon. If extraordinary circumstances video conferencing is used, it has to include which, if any, members participated remotely. For executive sessions, you only need to prepare minutes of an executive session if you vote in executive session. If you merely deliberate in executive session, but then come out of executive session prior to voting, then you don't need to prepare separate minutes of the executive session. You only need minutes of an executive session if you vote in executive session. Those minutes must be available within 2 weeks for an open session and 1 week for an executive session. And they have to be made available upon request, and we're going to talk about it in a second, posted online, regardless of whether they've been approved or not. If someone wants them, even if they're still in draft form, they have to be made available. In the fall of 21, which was an active time for the Open Meetings Law, Governor Hochul signed Chapter 587, which amended the Open Meetings Law to require agencies that maintain a website and use a high-speed internet connection to post their meeting minutes on their website within 2 weeks of the date of the meeting or 1 week of an executive session. The law states that for purposes of this subdivision, so for purposes of this posting requirement, an unabridged video or audio recording or an unabridged written transcript can be deemed to be meeting minutes. That does not mean that the public body, the community board, is relieved of the obligation to prepare minutes and make them available upon request. It simply means that if you would prefer to post an unabridged video or audio recording or an unabridged written transcript on your website instead of posting meeting minutes, you can do that. So I'll take a break there to see if anyone has any questions about what we've talked about in the last little bit.
Hi, Kristen. Quick 2 questions. So just to confirm, you said that meeting minutes can be bare bones. Just confirming.
All you are required to include is that what I sort of mentioned in the right there, that has to include a record or summary of all motions, proposals, resolutions, or any matter formally voted upon and the votes thereon. The language is a little different for executive session minutes, but not that different. Basically, it just says you can prepare your minutes in such a way that you don't defeat the purpose of the executive session. Beyond that, it is at your discretion what you want to include in your meeting minutes. Some public bodies practically do word for word. You know, they write down, you know, the person who prepares the minutes writes down everything everybody says. Sometimes people just include a little bit more and they'll say, well, we had 10 minutes of deliberations on this topic. Sometimes public minutes include summaries of public comment, sometimes they don't. Anything beyond that bare bones minimum of what the open meetings law says has to be in there is at your discretion.
Thank you. And my next to last question is, so confirming that video is okay for minutes, or can you clarify again? Let's say we post our YouTube, the YouTube video of this meeting. Would that count as our minutes for the community board?
It does not count as your minutes.
Okay.
What it does is if you would prefer to just post that YouTube video instead of posting the minutes of the meeting. It's kind of a silly provision, to be honest, in my opinion. I'm not sure if it saves people all that much work because minutes still need to be prepared. The goal of the minutes is, from my perspective, is to make it easier years from now. If someone wants to go back in 2 or 3 years and just find, you know, the real primary substance of what happened at this meeting, what resolutions were passed, what were the main topics of discussion. That's what you want your minutes for. Nobody wants to sit through a recording of a 3-hour meeting just to try to figure out, okay, what actually happened here? That's why you want to keep having minutes.
Thank you.
But like
You're
you said,
welcome.
it's up to your discretion, but it doesn't have to be word for word. It can be just summaries of the different bullet points on the agenda. And
You've got it.
Okay, perfect.
Exactly. Yep. All right. Recording. Any meeting of a public body that is open. Oh, sorry. Did someone have a question?
I do. So motions and resolutions are supposed to be included on the agenda that's posted beforehand. We had a situation recently where a motion came up that wasn't expected. Do we then delay that to another meeting, or how do we handle dealing with a motion that wasn't included on the agenda?
You're not prohibited. So for my purposes, I'll clarify that the word agenda really doesn't appear anywhere in the open meetings law. It's not used. So there's no obligation to create an agenda or to follow an agenda if one is prepared. But what is required, as we just talked about a minute ago, and I think that's really what you're asking about, is that any records that are scheduled to be discussed must be made available. So for example, if you're considering discussing and voting on a particular resolution, that resolution is supposed to be made available. If you do have an agenda, that agenda should be available 24 hours prior to the meeting. If something comes up during a meeting and it honestly was not, it's something that just sort of organically arose from the conversation, there's nothing that prohibits you from making that motion during the meeting. The goal really of that section 103E about records scheduled to be discussed is putting the public, the members that are sitting in the audience, on the same footing as the board members in terms of the documents that they have available to review. So if you as a board member have a copy of a resolution in front of you, that same resolution should be made available to the members of the public so they can follow along with the conversation. But that does not prohibit you from maybe making slight amendments to the resolution during the course of your deliberations. That's not prohibited by the open meetings law, and it's not prohibited for you to make a new motion that wasn't anticipated during that meeting. If you're unsure, if you really don't feel comfortable, if you feel like, okay, well, this is something that we should have had available to everybody to discuss, and none of us, even as board members, have had a full opportunity to really give this our full consideration and thought, maybe it's worthwhile to postpone it to a future meeting. But I just will let you know that there's nothing prohibiting you, nothing in the open meetings law that prohibits you from voting on a motion or resolution that was not ready to be posted 24 hours prior to the meeting. Maybe it did not even exist. Hopefully that answers your question.
Yes, it does. Thank you very much.
You are welcome.
Kristen, there's a question in the chat. Do you mind if I read it to you? And
Oh, great. Thank you. I appreciate it.
no problem. What if a vote is taken during a meeting, but the vote tally isn't crystal clear from the video of the meeting? Where does the public find the accurate vote, and how long do they have to wait for that info? That was Diana Finch.
No, yeah, and that's another good reason why it's good to have the minutes and not just relying on the video, because video isn't always as reliable as we would like it to be. So ultimately, whoever's responsible for taking minutes is going to need to include that information in the minutes, and the minutes need to be prepared within 2 weeks of the meeting. So even if you don't post them online, someone should be able to, for example, submit a FOIL request and obtain those minutes, even if you choose not to post them online.
There's a question in the chat from Diana Finch.
I
Yeah,
think we just did that, didn't we?
I just did that.
Sorry.
It's okay.
All right, I'll go on unless anyone has any other questions. We always come back to it. Executive session. Executive session is the first of 2 avenues that allows a public body to meet behind closed doors. And it's defined in the open meetings law as a portion of an open meeting that's not open to the public. So an executive session should never occur prior to the start of an open meeting, and it can never be 100% separate standalone from an open meeting. It doesn't mean that maybe an executive session can't take up 95% of a meeting. It's just that it always has to occur within the context of an open meeting. So you have to have an open meeting that is properly scheduled and noticed to the public. The public sort of have to be invited in for at least the beginning of the meeting. Then the community board needs to make a motion to enter into executive session. And that motion must be specific enough to reflect to fellow board members and to the public that you're going into executive session for a proper purpose. Then the motion is voted upon, and if it passes, you get to go into executive session. So this is sometimes where there's confusion, maybe lack of clarity about what those motions to enter into executive session should say. You're up on the screen right now, and again, I promise I'll send them out to people, and you can review these to your heart's content, these slides. Up on the screen right now, you'll see all of the reasons you're allowed to go into executive session. If you don't see it on this list, then it means that it's not a proper conversation to occur in executive session. The ones that come up most frequently, I'm going to say, let's see, A, B, C hardly ever come up. Letter D comes up probably more frequently than we'd like it to, which is discussions regarding proposed, pending, or current litigation. You'll notice that language is specific, so I'm going to focus on it. It's proposed, pending, or current litigation. It's not possible litigation. It's not prospective litigation. It's proposed, pending, or current. So it either has to be litigation that's already been filed, by the community board or against the community board. Or at a minimum, there has to have been some sort of notice of claim filed against the community board or by the community board indicating imminent litigation. Sometimes we see situations where a public body wants to discuss a sensitive topic in executive session because they fear it's going to lead to litigation. That is not permitted. What is permitted is you're allowed to discuss actual litigation, the actual case, not a topic that could lead to litigation. So for example, you discuss litigation strategy. Do we want to settle? Do we want to go to trial? These are the types of conversations you can discuss in executive session. You cannot take a topic that you would rather not discuss in public because of the nature, the sensitivity of the topic, and say, well, it could lead to litigation, so we're going to discuss it in executive session. That is not permitted. It has to be actual litigation. E is more common if you're a public employer. It's Taylor law collective bargaining negotiations. Letter F comes up frequently when you're dealing with matters relating to the employment of individuals. Very often we see public bodies using the phrase move to go into executive session to discuss personnel matters. Sometimes, again, going back to the earlier topic, move to go into executive session to discuss litigation. The courts have spent a lot of time on this subject. They, over and over and over again, have slapped public bodies on the wrist for not being specific enough. For example, if you're discussing litigations, the courts say you should be identifying the name of the litigation that you plan to discuss, like Community Board 11 versus O'Neill. You're going to discuss that you're going to identify the litigation. If you're talking about the medical, financial, credit, or employment history of a particular person or corporation or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation, they don't want you to say that. They don't want you to just parrot the language of the statute. They don't want you to say personnel matters. What they do want you to do is tell the public or tell your fellow board members, what are you actually going to discuss? Not in so much detail that it's going to defeat the purpose of the executive session, but just pluck out the parts of the language that are appropriate to your situation. Are you hiring someone? Are you moving to go into executive session to review resumes that you've received for a new district manager? Are you going into executive session to discuss the possible disciplinary action against a particular employee? No, you do not need to identify the employee. You just want to be specific. What are you actually going to talk about? Try to pluck out the parts that are appropriate for what you plan to talk about and leave the rest on the table. G is for exams, maybe civil service exams, or if you're in a school district. If I don't know if community boards ever purchase or sell property, but H allows you to discuss the sale or lease of real property, but only when publicity would substantially affect the value thereof. So if maybe you're considering purchasing a piece of property, but you didn't want everyone to know how much you're willing to offer for the property, this allows you to discuss that in executive session. Anyone have any questions about executive session? All righty. Avenue number 2 for meeting behind closed doors. Section 108 of the Open Meetings Law establishes exemptions. There are 3 exemptions set forth in the Open Meeting Law. If a discussion fits within one of these exemptions, the Open Meetings Law does not apply at all. None of the requirements of the Open Meetings Law apply if the topic of the conversation is set forth as one of these exemptions. So that's sort of the difference between executive session and exemption. Executive session is part of an open meeting. So a lot of the rules relating to Open Meetings Law are going to apply even to the executive session. Basically, the difference is the conversation can occur behind closed doors as opposed to an open session with executive session. If it's an exemption, you just throw the Open Meetings Law out the window entirely. For example, you could have a completely standalone conversation if that conversation fits into one of these categories. The most common, and I'm going to say, I'm going to say probably the most common here is for any agency. So the first one is, let me back up. The 3 exemptions. The first is judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. So this is, for example, if the community board was permitted by statute to have some type of hearing where you hear evidence and make determinations in a manner where you're making a final determination on behalf of your community board, and the only remedy to challenge that determination would be to bring an Article 78 proceeding in state Supreme Court. If you're the final decision maker, if the community board is the final decision maker after having a type of a hearing, that quasi-judicial proceeding is exempt from the requirements of the Open Meetings Law. The second exemption is deliberations of political committees, conferences, and caucuses. So often when you're running for some type of governing body, city councils, town boards, village boards, state legislature, you're running on political lines. So for example, if you have a city council, a 15-member city council, and 10 of those members are Democrats and 5 of those members are Republicans, those 10 Democrats could meet whenever they want, wherever they want, and talk about whatever they want without notifying the public. They can't vote, they can't make decisions, but they can meet and they can talk about whatever they want if they are all adherents of the same political party, even though they represent a quorum of the board. The third one, here's the one where I said was the most common. Any matter made confidential by federal or state law. And the example that comes up probably the most frequently is a meeting with your agency or public body's attorney where you're requesting and receiving legal advice from your attorney, and that conversation is covered by the attorney-client privilege. So the mere presence of your attorney in the room isn't going to be enough to trigger the attorney-client privilege. It would have to be a conversation where you as a board are seeking legal advice and the attorney is providing you with legal advice. Under those circumstances, those conversations are confidential pursuant to New York State civil practice law and rules and can be held outside the scope of an open meeting. In terms of compliance, the Committee on Open Government does not have enforcement authority. We are here as an advisory entity. If anyone that has questions about freedom of information law, open meetings law, at the state level, there's a state statute, the Personal Privacy Protection Law, that only governs records maintained by state agencies like the Department of State, Department of Labor, Department of Health at the New York State level. It does not apply to records maintained by a New York City agency or a community board. So it's not really something you as a government entity have to worry about. But if for some reason you as in your personal experience ever have questions about the Personal Privacy Protection Law, that is one of our statutes over which we have advisory oversight. But as I said, we're an advisory entity. We answer questions, provide advice, legal opinions regarding the open government statute. We try to be neutral to some extent. Let's put it this way. If someone from the government asks us a question and someone from the media asks us the same question, both of those parties are going to get the same answer from us because our answer is always based in the statutory language and judicial precedent. We're not advocates. Certainly, we encourage transparency whenever necessary and appropriate, of course, but we're not advocates. We're an advisory body. The enforcement of both the Freedom of Information Law and the Open Meetings Law is through the initiation of a CPLR Article 78 proceeding in state Supreme Court. Any aggrieved party under the Open Meetings Law, any aggrieved party can bring an Open Meetings Law Article 78 proceeding in order to obtain enforcement of the statute. In some circumstances, they may be attempting to invalidate an action taken during a meeting that they believe was not held in compliance with the Open Meetings Law. A successful petitioner can be awarded costs and attorney's fees if the judge finds that the violation of the Open Meetings Law was substantial. The court can determine to invalidate an action. There's actual language in the Open Meetings Law that says that actions should not be invalidated if the court finds that it was a mere technical violation. So if it's something small, if it's something minor in the court's eyes, they're not ever going to invalidate an action. There's language in the statute supporting that. If they find that it is a major violation where basically maybe just the community board just never noticed the meeting or has a habit of repeatedly engaging in behavior that is inconsistent with the requirements of the Open Meetings Law, under those circumstances, the court may invalidate an action. And there's a penalty that you can have to take training from me, but a lot of people do that voluntarily, so I don't think it's bad. But that's the end of my PowerPoint presentation, which I am going to send to you. But I will stop now and see if we have any more questions.
I have a question. What about if you, let's say, like my committee, I would like to have a dinner with them or some type of gathering. Is that allowed, or do we have to let the public know?
That's a good question. If it's a mere social gathering, you are welcome to have a social gathering. If you guys want to go out to dinner and just talk about your families and social events, maybe, national politics, you are free to do that. Just keep in mind that you need to sort of self-police and not engage in conversations related to your role as community board members.
Okay. Any other questions? Going once? Going twice? Going 3 times? Okay.
Thank you for
Kristen?
having me tonight. If you have any follow-up questions that you remember later, feel free to shoot me an email. You all have a lovely evening.
Thank you
Thank
so
you.
much.
Very
Bye-bye.
helpful.
Sorry I was late.
Take care. Bye-bye.
Bye.
Okay, we're still gonna continue our meeting. We're gonna go back to the beginning. So, hi, I'm Naomi Pemberton. I'm the chair of the Ethics and Disciplinary Committee.
Rich Reynoso, committee member.
Jeanette Wilson, committee member. Susan Perez, community member.
Okay, so, do we need to vote on the meeting minutes? Did anybody review that? Or we can leave that for the next meeting? Anybody?
Do we have the quorum?
Yeah, we have a quorum.
Yeah, I read them. So.
Okay. We'll leave the vote for this the last minutes and this meeting's minutes for next month. Is that okay with everybody?
Yes.
Because
Okay.
We're kind of getting back into the groove, okay? Okay, so, today also, since we have a quorum, we're gonna be doing committee chair elections. I'm not really sure how this is supposed to go.
I think you just someone nominate somebody else.
I nominate Wendy.
Naomi.
Sorry.
Naomi.
I'm sorry.
Okay. Quick. Okay.
Okay, yeah.
Okay, all right, so, the motion is so carried. Naomi will remain chair.
Yeah.
So I motion,
Sorry.
or I nominate Jeanette to be vice chair.
Second.
I'm gonna pray for both of you tonight.
So the motion carries that Jeanette will be vice chair. Okay, so we have certified election. So our new chair will continue to be Naomi Pemberton, and Jeanette Wilson will be the vice chair.
Congratulations,
Co-chair.
ladies.
Co-chair. Thank you.
Thank you.
Okay, so
Did we put it out there that if there are any community members online, that we welcome new additions to the committee?
Absolutely.
oh yes, if you are a committee member of the board 11,
Yes.
we welcome you to join our committee. We are a fun committee. I'm going to definitely do a dinner now that I heard from open meetings law that I can have a dinner. I want to definitely do something social with everyone this year. So please join if you'd like to. It's a fun group.
And we're going Dutch.
I'm going to.
And we're going Dutch, because that's the way to do it.
I'm gonna see about that. We'll see about that. So, okay, so that's good. Now we can open
Where is he?
the gallery. Is anyone registered for the gallery? Is Jeremy on? Let me know if anybody registered tonight.
You're gonna write?
Okay, so I don't hear Jeremy, so I'm gonna ask anyone on the call today or in the room, if you have any questions or you want to speak on any items, please raise your hand.
Naomi, can you hear me?
Cynthia, is that you?
Yes, it is.
I can hear you now.
I just want to thank you for bringing this presentation so that we can clarify a lot of issues. I appreciate the time and effort you put into arranging this.
Oh, thank you. Thank you. I wanted to start our year out right and clear as possible because there was a lot of confusion last year. So, and I'm so glad Kristen came on tonight because she really clarified a lot of things for me as well. So, and we'll have the presentation also to refer to.
Okay.
Does anyone want to speak tonight on any issue or concerns?
Anything?
Nothing? Okay, that means we're doing a good job.
Yep.
Woo-hoo. Right. Are there any motions this evening? Anybody want to make any motions? Okay. Any old business? Any new business?
We have a guest speaker in October.
Yes, so we're gonna have a guest speaker in October from Human Rights Specialist Samuel Lopez. If you please email me by Friday if you have any particular topics that you want him to cover. But I wanted him to go over the New York City Commission of Human Rights and what their expectations are. And also, you know, handling inappropriate comments or concerns in relations to race, if any, you know, and how, you know, how do we handle that if we have those kind of issues? So please email me by Friday and I can add your topic so that he knows what he wants, you know, what he could present on. Okay. So any questions, concerns, comments? That's great. We're doing a good job. Good job. It's silence. There's silence. So, well, then I'm going to motion that we're ask for someone to motion that we adjourn.
Motion to adjourn.
Anyone second it?
Second.
Okay, so we're going to adjourn. Have a good night, everyone.
I'm safe,
Get
everyone.
home safe. Okay, thank
Thank you for
you.
joining us.
Thank you.
You have questions for us? Oh, okay.